Okay, welcome everyone. People are still arriving, and I'm sure many more will arrive throughout the day, but welcome. Welcome to In Search of the Concrete Universal, a conference in honor of Sheila Ben-Habib, or as some of us have come to call it, welcome to Ben-Habib Fest. I also want to welcome all the panelists who are going to be speaking throughout the day, and in particular, I want to welcome Sheila Ben-Habib. So my name is Stefan Eich. I teach in the government department at Georgetown, but before that, I had the infinite fortune of having written my dissertation at Yale under Sheila's direction. And it is a real honor and pleasure to welcome you all for this festive occasion. As many of you will know, we had to postpone a 2-day version of this conference in March of this year due to COVID-19. And while we still hope to eventually get together in New Haven in one form or another, we also hope that today's conference, structured around a festschrift for Sheila Ben-Habib, is not just a remote substitute, but will instead be a distinctly global celebration in its own right. And I'm not exaggerating when I say that we've been inundated with RSVPs over the past weeks. We've received more than 600 RSVPs from all around the globe, from Frankfurt and New York, Berlin and Istanbul, but also Brazil and Belarus, India and Iceland, Sydney and Los Angeles, and often accompanied by stories of former students of Sheila's whose lives had been changed by meeting her. What's more, many scholars based outside the US, especially from the global South, convey to us their excitement about being able to participate in a way that would otherwise not have been possible. So while we are on Zoom and while we can't share Turkish food for lunch and a glass of white wine in the evening, what could be more fitting for Sheila's unique ability to detect in moments of distress new possibilities for communicating with one another, to find in concrete situations of adversity traces of the universal, to bring together her students and readers, friends and strangers. Now, there are a lot of people and institutions without which this would not have been possible, and I want to thank them for putting up with us in the first place. At Yale, the Department of Political Science and the Department of Philosophy, the Macmillan Center for International and Area Studies, and the Whitney Humanities Center. At Columbia, the Center for Contemporary Critical Thought, and last but not least, the fantastic staff at Georgetown, who've made it possible for us to set up a Zoom conference on this scale. Thank you. Thank you in particular to all those countless helpers that have been working on this invisibly behind the scenes and are continuing to do so throughout the day. But all this institutional support would have meant nothing without my dear friends and co-organizers. Without Blake Emerson and Turku Isiksel, this whole endeavor would not have gotten off the ground. Without Anna Jurkiewicz, Nika Siegel, and Nishin Nadwani, we would quite literally not be here today. A lot has happened in our lives, both difficult and joyful, since we first sketched the idea of the conference. And I'm just so happy and proud to have been part of this team and to be here with everyone today. Thank you. I won't take any more time since we have a very packed schedule ahead of us, but let me conclude with 2 very brief logistical announcements. The first is that you can find the schedule for the day on the conference website, and you should have also received it as a poster attached to the RSVP email. So that's concreteuniversal-benhabib.com/program. Secondly, we want to make this day as interactive as possible, and we encourage you to use the Q&A function liberally and generously throughout the day. And Nishin Nadwani will say a little more about this in a minute. So, okay, I will shut up now and make room for the first panel. And I just hope that you can join us throughout the day in this celebration of Sheila Ben-Habib's thought, work, teaching, and mentoring. Welcome, everyone. So with that said, I hand it over to Nishin, who's going to say a few words about the first panel and the technicalities of how to ask questions. And then Tom McCarthy will get us going.
Excellent. Thank you so much, Stefan. It's wonderful to see so many friendly faces here after the months of planning. So thank you for being with us both near and afar. It's wonderful to have you here. Before I introduce the chair of the first panel, I just wanted to bring your attention to the Q&A function in Zoom. You'll notice there is a Q&A button at the very bottom of your Zoom window. If you click on this button, a tab will actually pop up on your screen, and you'll be able to enter questions in this box for the presenters at any point throughout the session. So just to reiterate, you do not have to wait until the formal question and answer period in order to submit questions. In fact, we would encourage you to submit your questions as they arise. This will allow us to go through the questions, filter them, pre-select them, so that we have a few questions ready to go when the chair opens the formal Q&A period. We would also just ask you to indicate when you submit your text question, whether you would prefer to articulate the question in your own voice or to have it read out on your behalf. Now, we can't unfortunately promise that we will be able to honor every request given the time constraints. The vast majority of the questions will likely be read out to the panelists during the Q&A period. However, time permitting, we would love to give a few of you the chance to ask questions in your own voice. So please do let us know if that is a preference of yours. Okay, so without further ado then, I will introduce the chair of our very first panel on cosmopolitanism and contested universals, and that is Professor Thomas McCarthy, who is John C. Schaefer Distinguished Professor of Humanities Emeritus at Northwestern University. So Professor McCarthy, it's a great honor and pleasure to welcome you, and I'll hand it over to you for the first panel.
Thank you very much for getting us started and for all the work you and your co-organizers put into organizing this unique conference under singularly difficult conditions. Let me now introduce the panelists, all of the panelists, and I'm supposing they'll be speaking in the order in which they're listed in the program. Our speakers are Angelica Bernal, an associate professor of political science and the director of academic Fellows Program at the University of Massachusetts. Drusilla Cornell, an emerita professor of political science, comparative literature, and women's gender studies at Rutgers University. Paul Lyndon Rettich, a lecturer in law and society at the University of Buffalo School of Law. Peter Verovchik, a lecturer in politics and international relations at the University of Sheffield. And Christina Lafont, my very good friend and former colleague, is the Harold H. and Virginia Anderson Professor at Northwestern University. And finally, Umur Baştas is an assistant professor of international relations at Koç University in Turkey. And then if there's time at the end, I'll be making a few remarks as well. I should say that the question of time is particularly pressing with this panel because we have a total of about almost 80 minutes, but we have 7 speakers. And so if people speak for more than 10 minutes, we'll have a problem with either getting in all the talks or taking up any of the questions that are submitted. So I would suggest or plead that you try to limit your remarks to 10 minutes if that's at all possible. When you hit 9 minutes, I'll wave this little card and you'll know that it would be appreciated if you could somehow bring it to an end in the next minute or so. Okay, having said that, let's go on to our first speaker.
Thank you, Professor McCarthy, and thank you to the organizers for putting together such an exciting day. So I'd like to begin my talk by acknowledging that where I stand is non-talk land. 19 years ago, when I entered the doctoral program at Yale, one of the first things I learned in Professor Ben Habib's class is the power of narrative. So in that spirit, I'd like to begin with a story. On August 20th of 2019, hundreds gathered inside the courtroom of the Pastaza Judiciary in the town of Puyo, Ecuador, to listen to hours of arguments surrounding a planned hydroelectric plant on the Piatua River. The hearing was initiated by indigenous Quechua people from the communities of Santa Clara who sought a protective injunction to halt plants by the Henafran Hydroelectric Company. Now, since the company was first granted an exploratory license in 2014, indigenous groups have been resisting in a range of ways, from road blockades and marches to protests on social media, and most recently, a lawsuit. In this resistance, indigenous people challenged not only the company's actions, but the state's authority, as well as the legitimacy of their claims to sovereign management and exploitation of natural resources. And they did so in novel ways. Indigenous groups argued not only against the environmental impacts of building the dam, but they also argued to stop the dam on the basis of a new juridical category, the rights of nature, which in the 2008 Constitution became the first country to recognize. Mainly in these claims, indigenous groups asserted the rights of the Piatua River itself as a sacred site. No other thinker of the past few decades has been most associated with cosmopolitanism and its contemporary revival than Sheila Ben Habib. In the brief time that I have today, I'd like to focus my reflections by situating Professor Ben Habib's cosmopolitanism in the context of rights of nature cases and our current planetary crisis. At the heart of Ben Habib's project has been addressing the tension between emergent cosmopolitan norms and the will of democratic majorities. Threading this tension, as Ben Habib has done through her framework of democratic iterations, allows contemporary constitutionalism to fully emerge, not merely, and I quote her, as a privileged attitude of globe-trotting and world-hugging elites, but to reflect the concerns of ordinary citizens. I want to go a step further and argue that in this and in the context of indigenous struggles, democratic iterations can also reflect a shift in epistemological, cultural, legal, and political grounds towards what Walter Mignolo has called a decolonial cosmopolitanism. To begin, a little about what is the rights of nature. The rights of nature represents not only a constitutional right in Ecuador, but 4 decades long global movement centered on an understanding of nature as an agent deserving moral respect, ethical treatment, and with it political and legal rights. In another cosmopolitanism, Ben Habib outlines the emergence of an international human rights regime since 1948 that has transformed human rights codes into generalizable norms to govern the behavior of states in the areas of crime against humanity, humanitarian interventions, and transnational migration. Today, we are witnessing a further evolution that now includes environmental norms, from the Rio Convention to the Kyoto Protocol and Paris Agreement, to name a few. The rights of nature have been a critical part of this evolution. They reflect the interpenetration between, on the one hand, transnational activism and emerging international norms, and on the other hand, regional and national activism and norms surrounding popular ecology, post-neoliberal development, and indigenous rights to collective self-determination. These collective rights have included rights to bilingual education, territory, culture, intellectual property, legal authority, political governance, and free, prior, and informed consent. They have been elaborated over 4 decades in documents like the ILO Convention 169 and most recently the UN Declaration on the Rights of Indigenous People in 2007. In the last wave of constitution making in Latin America, these principles were incorporated in constitutions of many countries from Ecuador to Bolivia. The incorporation was part of larger decolonial projects to refound the state by adopting more autochthonous models against the global north, many of which, like the rights of nature and development regimes like El Buen Vivir, centered on indigenous cosmologies. In the context of Ecuador, where I base my research, democratic iterations have occurred in 3 main domains. First, within the 2007-2008 Constituent Assembly. The Assembly reappropriated human rights principles developed in ILO 169 and the UN Declaration on the Rights of Indigenous People, infusing them with new constitutional meaning as the rights of nature, or the rights specifically of Pachamama, the Quechua Andean term for Mother Earth or Mother of the Universe, space, and time. It also reappropriated emergent transnational and regional norms developed through the World Social Forum, the European Social Forum, Cancun COP16 and other COP meetings, as well as the Inter-American Commission on Human Rights, which in 2012 issued a critical indigenous rights decision in the favor of the Sarayaku people of the Amazon in Ecuador. Now, second has been popular constitutionalism and activism by indigenous and ecological movements. This has been a critical domain for public opinion mobilization and formation, given 2 troubling developments in the aftermath of the 2008 Constitution. The Correa's government pursuit of aggressive extractivism and its attempt to co-opt these original achievements through the government's development of Buen Vivir. El Buen Vivir, or Summa Causai, which translates as the good life, was supposed to be a new model of development to create a bio-socialist republic. And in discourse after discourse, Ecuador's president rightly proposed that a critical mission of the state was to alleviate poverty, but wrongly sought to do so by establishing the good life of all on the backs of indigenous people, by expanding the extractive frontier from petroleum to mining. Now, throughout this period of neo-extractivism, rights of nature emerged less in terms of successful cases or litigation and more in terms of new discourses of political resistance. Protest after protest saw indigenous and non-indigenous alike speak of keeping it in the ground because the land is our mother, oil is blood, and the rainforest is a living being that can't be exploited or sold. Now, lastly of these democratic iterations has been the courts. Between 2008 and 2016, 10 out of 13 cases successfully applied rights of nature norms. Yet many of these cases were used to protect governmental or private landowner interest. For instance, to squash down on artisanal mining and clear the path to government monopoly on mining activities, as well as to assert police, state force, and military presence in rural community. But since then, there have been 3 new cases that have applied rights of nature norms to cancel extractive activities by transnational corporations. One of these includes an internationally high-profile case brought by the Guarani Amazonian nation, whose indigenous president, Nemonte Nenquimo, was recently named in Time's list of 100 most influential people in the world and was awarded the prestigious Goldman Environmental Prize. As we have seen with the pandemic and the increasing manifestation of climate change devastation, from wildfires in California and the Amazon to stronger and more destructive hurricanes in the Caribbean and record floods, our contemporary condition is one that makes more visible our mutual dependency as a species with our other than human environment around us. In The Rights of Others, Ben Habib offers us a definition of cosmopolitanism that speaks perfectly to our condition. Cosmopolitanism as concern for the world as if it were our polis. The Ecuadorian case of Pachamama's rights reiterates this in a new direction, towards decolonial projects that affirm a care for our polis as if it were our cosmos, and for building international solidarity and collective power to generate urgent action. Thank you for listening.
Thank you very much. Why doesn't our next speaker, Drusilla, begin right away? Drusilla? Is Drusilla
But
here?
she's muted. Drusilla, you have to unmute yourself first.
I'm muted?
I'm unmuting. Did I succeed?
Yeah.
Cool. Shayla is truly a great dialectical thinker. Obviously, dialectics is a philosophy of the material world. I want to say what I mean by this. Shayla, over and over again throughout her work, has intervened in situations where the opponents were simply throwing rocks at one another. In feminism, it was amongst those who were for justice, autonomy, personhood, those who were for women's sexual difference and the ethic of care. And what did Shayla do? She came up with a integrated way of saying you're both right, but there has to be a much richer way of thinking about it, and wrote her book on the situated self with the generalized and concrete other. That spirit of dialectics informs all her work. My challenge to her today is just to continue with her fine thinking, which is that she has always distinguished and criticized liberal nationalism, liberal internationalism in the name of cosmopolitanism. I am advocating for a fourth normative position called transnational decolonization. And in a certain way, I think we have to see that Ben Habib's cosmopolitanism is way beyond her mentor's Habermasian notion that there's something called global determinative deliberative society that can generate abstract norms. What Shayla's always looking for is concrete universals. And I want to use to show what I mean by transnational decolonization examples from the South African Constitution, a document explicitly written to create a new moral, not just a new legal order, because the crime against humanity was apartheid itself. 2 examples. The South African Constitution is monist. It integrates all international law in it. If there's a conflict, it has to be reconciled as a matter of constitutional mandate. But in a series of very important judgments, Laurie Ackerman took Section 10 of the Constitution of South Africa, which reads, everyone has dignity and everyone has the right to have their dignity respected. What Ackerman did, and this is a generation of concrete universals, is take the everyone has dignity and develop it into a series of judgments which now have traveled around the world, that dignity is itself a cosmopolitan norm. And it's interesting because those may talk about it in dignity and adversity, which is certainly what Laurie was doing, and say, but that norm, that morality is not just, even though it's generated in South Africa's struggle against apartheid, it's by no means limited there. A more controversial, perhaps more complex case is Yvonne Makuro's judgment in her COSA case, where she has to face whether or not non-South African citizens should have full socioeconomic rights. Her answer was yes, under a South African ontology and ethics called Ubuntu. Way beyond my 10 minutes to explain to you what Ubuntu is, but I can tell you this. It's about a way of looking at the human being that we cannot even survive, let alone flourish or individuate without support. And it's that Ubuntu has become one of the most important ways that socioeconomic rights, which are extensive in South Africa, are justified. But what did Justice Makuro use? She said, because of Ubuntu, people who are not citizens of South Africa must have, under what Ben Habib calls the right of hospitality, full socioeconomic benefits, the same as citizens. Now, in that way, Ubuntu has traveled now. It's actually in European jurisprudence. You see the development of concrete universals out of a decolonizing, which is what the struggle against apartheid was, to create different universals that come from a specific place. Ubuntu is South African, Ubuntu is African, but it is limited in its reach. And this comes to two of Ben Habib's most important concepts: juris-generative politics, which he borrows and interprets from Robert Cover, and very proudly, for my sake, democratic iterations from Jacques Derrida. The reason this is so important in these two cases is the juris-generative politics of Justice Laurie Ackerman set an entire jurisprudence that allowed dignity to reach way beyond just what we would think the positive law was. In the case of Justice Yvonne Makuro, the right to hospitality now has become crucial in a whole series of new cases before the Constitutional Court that will include can non-citizens vote and how can non-citizens vote, and all of the issues that have been so important. That's a classic case of democratic iterations, and here's why. Because a lot of people would say, well, you can't take an African value, something rooted, it's a Zulu Xhosa word, and say, well, no, now it has universal reach, but you can. And that's what a democratic iteration is. There's no such thing as a purity of African values. On the other hand, if genocide is not just the brutal murders, but also the extinction of a way of life, and this just came from our former speaker, the recognition of indigenous values in the global South has to be part of our revising and rethinking of international law. Now, did I come up with this idea of transnational decolonization on my own? Of course not. It comes from a famous conference in Bandung, Indonesia. This conference took place between April 18th and April 29th in 1955. One of the interesting points here is that that conference was all global South nations, some of which we would not consider global South anymore, like Japan, but there were no Europeans present. And here is what a group of young scholars have said, and I think we all have to think seriously about it. The Bandung inserted the concepts of equality and justice into international law in a way that cannot be undone. Bandung's significance for international lawyers arises from the fact that it's both an idea and a project, a collective imagination of a new world, and a practical effort to make that idea into a reality. It is from every generation to argue and debate over what justice and equality mean for international law. And in doing so, to resist normalization and to open the possibility of an alternative and more just and fair world order. Do I think Benhabib's own cosmopolitanism can grapple with the spirit of Bandung and the challenges of transnational decolonization? The answer is absolutely yes. And I read a quote from Benhabib. My concern is less with the kind of universe in which cosmopolitan norms can be said to exist than with these norms, whatever their ontological status, can shape, guide, and constrain our political life. And by so doing, creating new spaces for evaluative articulation and extending our political imagination. In Bandung, Fanon was constantly quoted. His quote is, "It is a question of the third world, starting a new history of man." Whatever you make of that quote, the generosity of spirit in Benhabib's cosmopolitanism will allow her to take this fourth normative position seriously and to integrate it into her work on cosmopolitanism. Thank you.
Thank you very much. Am I muted or unmuted?
I'm
okay. Yeah.
I think
okay, fine. And we'll have, thank you, Giselle.
That
I
means
don't know whether they shut me out or not. So now we'll be hearing from Paul Linden-Rutte.
Thank you, Professor McCarthy. And it really is just a wonderful privilege and joy to be able to celebrate and honor someone who's meant so much to all of us. So if there's one principled moment by autobiography or by analysis that Professor Benhabib's work centers, it is, I think, the cosmopolitan moment. Diasporic, searching, tenuous, critical, transformative. The figure of the refugee, the exile. Baudelaire, in his famous poem, The Swan from Fleur de Mal, recalls successive images of dislocation and loss, beginning with the swan itself. Silly, like all exiles, he says, and sublime, endlessly longing. I want to linger a little bit on this. The sublime of the exile has something to do with an endless longing. Can one live between categories, at the edge of inclusion, beyond the bounds of political community as one inherits it? How to recover agency in this in-between? How to give an account that seeks not just to correct for that in-between, but to treat it as a moment of sublime inspiration for something otherwise, to find in that in-between a new way to live that leaves the injustices of the old behind. To think the political beyond nationality or any other inherited memberships and distinctions, and to think the human politically. Professor Benhabib's work suggests enduring and vital insights into these profound questions. I want to explore today a particular context in which such questions are being asked and in their own ways answered, and to consider how thinking informed by Professor Benhabib's insights might reveal a great deal more at stake in those answers. In recent political and constitutional thought, much scrutiny has been devoted to the transformations of sovereignty in these times of globalization. Scholars considering the European Union's political development in particular have creatively suggested forms of political rule that disaggregate or divide sovereign authority between national and supranational units and among a variety of institutions and rights regimes across overlapping jurisdictions. Nevertheless, as much as the reshuffle of sovereignty has channeled political power in these novel ways, it has not succeeded, at least not yet, in transforming the conception of sovereign power itself. Sovereignty remains imagined as a principled ordering or an authoritative, decisive command, an exercise of the faculties of reason and will. In either case, the investment in sovereignty as an imposition of mastery remains, even as the objects to be governed may have changed and might overlap in interesting, often curious ways. In this reordered political space of the EU, the European Union, we encounter various deformations, corrosive illiberalisms, an internal fiscal hegemony of German-crafted ordoliberalism, and an externally a violent regime of border control and migration deterrence. These are all very complex problems, but they together signal a distinctive concern, where we find an architecture of power, but not a transformation of power itself, nor a transformation more specifically of that desire for mastery that remains at the root of modernist sovereign authority. If new relationships are created in this architecture of power, they are rather thin and transactional ones, market-inflected, intergovernmental, executive-led, administrative in character, and not least deeply exclusionary at Europe's external borders. Professor Benhabib has been calling attention to these deformations and deficiencies for much of her career. They suggest a limit to our imagination about politics and public power, either a narrow liberal nationalism or an increasingly insulated and violently self-sufficient continental regime. These are the registers of sovereign realignment, but they betray a rather fundamental misunderstanding of the problems, struggles, conflicts, and miseries of the present. They retreat from the task of a more fundamental and foundational democratic critical renewal. The enduring investment in sovereignty as mastery neglects the potential of sovereign authority to relate individuals and communities, not merely to order or to command without interference. And thus it limits the promise of a post-national form of sovereignty that could more creatively transform a political community's claim to self-identity and the terms of recognition and acknowledgement it sets for its relationship with others. In response, I've wondered very much about Professor Benhabib's concept of democratic iterations, of course, as the basis of an alternative conception of sovereignty, one better suited to those transformative demands of post-national politics. As its terminology suggests, the concept is a delicate balance of thinking in modern and postmodern registers, a normative commitment to democratic agency, and an acknowledgement of the iterable and iterated character of shared normative meaning. It is this balance that promises political agency while rejecting the lure of mastery. How so? Democratic iterations reframes the work of rational opinion and will formation as a process of remembering, contesting, reinterpreting, and reconfiguring public norms. This is a recurring, creative, generative process. Its iterative character hinges on the ability of political subjects to see in the past a contingent experience that could have been otherwise, to rescue surplus meaning from the categories and events one inherits. Perhaps in the spirit of Walter Benjamin's pearl diver, who selects his precious fragments from the pile of debris. Iterations might appear in their own way as a rich and rather strange form of autonomy, a sublime, if endless, longing, in a sense always deferred, but also redemptive, possibly, of the norms that it carries. Precisely this temporal character suggests, however, that the proper domain of democratic iterations is neither reason nor will, which suggests a rather more limited, less dynamic notion of political time. Consider if democratic iteration centers instead the faculty of judgment. To conceive sovereignty as the authority to judge advises a distinctive mode of sovereign self-authorship, in which legitimation no longer attaches to the coherent unfolding of commitments on the basis of norm or decision, but instead to keep alive a shifting web of narratives whose meanings are fragile and complex and interdependent. This special character of judging re-signifies the universal over time and takes responsibility for the partiality of any such re-signification. That is to say, at the heart of a particular claim to judgment is the admission of its constitutive limits, dialectical movement of the concrete universal. Sustaining this character of judgment means acknowledging, with Hannah Arendt, the fragility of political action. Action relies on the interpretation of others for the disclosure of the action's meaning, and with that meaning, the identity of the actor. This is how the forces that had previously consolidated the universal, a preceding and overriding concept or rule, are revealed to be more contingent and less fully comprehended in themselves. And this is how, in the course of iteration, the identity of a democratic public itself can intelligibly change. I want to suggest that we see in this a structure of post-national sovereign authority. This might appear to be an odd way to capture a sovereign relation, but consider if we read the currently vogue theories of mixed constituent power in the EU precisely in this manner. The national and supranational pendants of that mixed power create a space in which this distinctive capacity for judgment can arise, a space intended to disclose the iterative character of norm and decision. And consider how disclosing this iterative character entails, in part, demystifying the contingent and historical balance of peoplehood, the complex entanglements of political economy, the cultural and ideological presuppositions that are consolidated under the heading nation state or the international system. Iterability is a form of decentering, of immanent criticism brought into the business of democratic agency. But there is a further vital consequence of this way of thinking about sovereignty in a globalized world. The joining of sovereignty to judgment suggests the vital place within the post-national constellation, as Professor Benhabib has long emphasized, of refugee and asylum law. By returning the democratic citizen to the fragile grounds of action, we also connect to the democratic citizen to the fate of the refugee. The protection of the rights of others is itself a condition for democratic judgment. It is the mechanism by which democratic judgment in a globalized world can intelligibly proceed. Indeed, understood as an iteration, the legal claim of the refugee avails itself of the same form of normativity as does the political standing of the social critic or the critical hermeneutics of the common law judge. Despite a veneer of human rights simpliciter, the legal claims of the refugee do not project a view from nowhere. Instead, they reveal a view from just outside the walls of the city, without which the symbolic and material repressions of the polis, and thus its ethical limits, would remain illegible, unamenable to judgment, and thus, in the end, democratically illegitimate. Professor Shahram Khosravi, in a recent essay, recounted the following story of a deportation from Europe to Afghanistan. Early in the afternoon of May 8th, 2019, people who were in the departure area of the Budapest International Airport witnessed several police officers dragging a woman towards a gate to put her on board an airplane for deportation to Kabul. She resisted and screamed words which historicized a potential future for many of us. One day you will be refugees too, like me, and that day you will remember this day. The presence of the stranger, Khosravi writes, reminds us of a past we don't want to remember and a possible future we don't want to imagine. What will we have remembered? What will the other have made us remember that we otherwise have worked so hard to repress, to keep out of mind? The contingent comfort of our own security, of personhood, of home, predicated on the tolerance of dislocation and despair elsewhere. What will we have remembered? What will we have learned about ourselves? Who will we have then understood ourselves to be? It is a curious arc of memory and narrative that the judgment of others presents to us, that accepting the open iterability of our norms and decisions reveals. As Professor Giora Binder once put it, every act of sovereignty inscribes a history upon the ruled. Every history is a claim to sovereignty. The contradictions of national sovereignty in a globalized world will remain until we have perceived the depth of this idea and find a way to bring these sovereignties, dueling and violent, into the frame of a common world we share, in which democratic judgment is again possible. Today, we honor Professor Benhabib's extraordinary achievements of mind, of heart, and of vision. Doing so offers its own arc of memory, an invitation to consider the many ways our own lives have changed for being entangled for a time with hers, with her thinking, her scholarship, her guidance, and our own capacities for responsibility and for judgment grew because of hers. Thank you very much.
Thank you very much. And now we have our next speaker, who is Peter Verovsich.
So thank you very much, Tom. It's good to see you, and it's good to see you all. It's my great honor to be here, to speak here, and to be able to honor Sheila Benhabib, who has meant so much to us all. In my brief remarks today, I want to focus on how Sheila Benhabib brings together, builds on, and surpasses the insights of Hannah Arendt and Jürgen Habermas in developing her own form of cosmopolitanism. So in contrast to the traditional methodological nationalism of political theory, over the course of the 20th century, cosmopolitan ideas have increasingly come to the fore. A particularly powerful strain of this new movement builds on what I like to call the communicative turn in continental political theory, which focuses not on language or grammar, but on the central role of communication, of shared meaning, as a form of action whereby individuals form communities and engage in politics. In her Cosmopolitanism, Benhabib responds to the work of Arendt and Habermas, Despite the fact that all three of these thinkers offer talk rather than vote-centric conceptions of cosmopolitanism, their models differ in important ways. Most notably, while Arendt builds on ideas of the public realm as a space of communicative appearances in order to develop a cosmopolitanism based on cooperation between local councils, Habermas instead argues for a deliberative post-national constellation built on continental regimes and a transnational public sphere. Ben-Habib seeks to reconcile the insights of her predecessors by offering another cosmopolitanism, to recall the title of her book, that reconciles what she calls the concrete and the generalized other. The basic thesis that I want to defend here today is that Ben-Habib's approach effectively mediates between the localism emphasized by Arendt and Habermas's push for a post-national constellation. So let me just build that out a little bit in the brief time that I have. In order to combat nationalism, imperialism, and anti-Semitism, sort of the three key elements that she identifies in the origins of totalitarianism, Arendt goes back to the Greeks to look for bits of the past that have undergone a sea change and survive in new crystallized forms. She eventually settles on local councils as a possible grain of sand from the past, which had, quote, waited only for the pearl diver to bring it up into the world of the living, unquote. Arendt locates this pearl of insight in many examples of action in concert, including Thomas Jefferson's ideas for the development of local wards in the US, the Paris Commune, the creation of the Soviets in the first day of the Russian Revolution, the 1919 German Spartacist revolt, and the short-lived Hungarian Revolution of 1956, to name just a few examples. Although Arendt's proposals for communicative cosmopolitanism based on the council system are thought-provoking, she never clearly or systematically sets out her thought in this area. As a result, although her basic insights are pregnant with theoretical potential, they remain unconvincing. For example, as all her historical ideas or sort of images indicate, a system of governance based on local councils has never endured for any extended period of time. While these revolutionary institutions can indeed be seen as proof of the enduring human capacity to act in concert, Ben-Habib points out that Arendt's faith in the council system, quote, seems to fly in the face of the realities of the modern world, unquote. So, building on Arendt's underdeveloped notion of this networked council system, Habermas seeks to develop an approach based on the transnational integration of nation states into continental regimes. He argues that the success of the European Union shows that cosmopolitan integration can succeed without destroying structures of local and state governance through the creation of an all-encompassing despotic world state. Although Habermas's model focuses on the development of these new institutions beyond the nation state, his conception not only delegates powers up to these new transnational organizations, it also devolves many competencies down to the local levels, where a more Arendtian form of politics prevails. This vision, based on regional or comprehensive regimes that sit between existing states and a reformed UN, has much to recommend it. However, its reliance on such global forms of regional integration is problematic, as such institutions do not appear to be forthcoming. For example, although he repeatedly points to the EU as a model, there is little evidence for similar developments in other parts of the world. Additionally, the prospect for reform of the UN has also faded over the past few decades, as states and other local political actors have increasingly proved unwilling to cooperate in intra or supranational institutions or to implement international law and global norms. In light of these developments, Habermas's communicative cosmopolitan vision appears to be further from reality now than it was when he proposed it at the end of the 20th century. For the perspective of the present, his vision is too institutional and relies too heavily on the development of supranational organizations and the direct enforcement of international law. Unlike Arendt's understanding, which is based on these councils that cannot seem to last and where it's unclear how they will cooperate with each other, Habermas's model suffers from, in a sense, just the opposite problem. Building on the insights of her predecessors, Ben-Habib seeks to mediate between sort of the universal and the particular, or the supranational and the local, by relying on local actors to implement global norms within existing institutions. Although she endorses a multi-level approach similar to Habermas's, Ben-Habib criticizes the rigidity of her mentor's distinctions between the levels of sovereignty within a cosmopolitan system. She instead seeks to blur these conceptual boundaries by calling for, quote, a dynamic understanding of interaction between courts, civil society, and social movements, unquote. Ben-Habib thus modifies Habermas's approach by emphasizing local agency in an Arendtian manner. This strategy, which seeks to square abstract universalism with local diversity, builds on her distinction between the generalized and the concrete other. Whereas the former recognizes the humanity of alter as, quote, a rational being entitled to the same rights and duties we would want to ascribe to ourselves, unquote, the latter acknowledges the uniqueness of beings with, quote, a concrete identity, history, and effective emotional constitution, unquote. Mediating these two perspectives requires working through how general moral rules can be applied in specific communities with their own traditions, histories, needs, and desires. This process encourages us not to essentialize the other by guarding against the tendency to regard the desires of different communities as uniform. On the contrary, Ben-Habib emphasizes that we must keep in mind that the aspirations of alter are also, quote, constituted through contested practices, just as our own, unquote. The normative lesson of this insight is that discursive engagement can spur the concrete other to take up universal norms from within. Ben-Habib argues that deliberation within the domestic public sphere allows communities at the local level to accept generalized cosmopolitan rules without the need for external intervention. In the process of these discursive democratic iterations, she notes that, quote, cosmopolitan norms are suffused with historically specific content, unquote. This not only mediates between moral universalism and democratic self-determination, it also infuses abstract ideals, quote, with content by drawing on experiences that could not have guided those rights in their initial formation, opening up new worlds and creating new meanings, unquote. By encouraging local activists to push for the incorporation of global principles into national and other domestic legislation through bottom-up processes, Ben-Habib argues that, quote, the content of democratic law is progressively reconstructed along lines that reflect principles of ethical universalism and cosmopolitanism, unquote. In addition to embedding the communicative cosmopolitanism within law and norms at the local level, this approach has the advantage of encouraging local actors to enter into the public sphere and to develop what Ben-Habib calls new vocabularies of public claim making that can anticipate new forms of justice that come in processes of cascading democratic iterations. More importantly, because they come from the inside and are generated from the bottom up, such an approach is less likely to generate resistance and hostility, unlike direct interventions or international pressure campaigns. Finally, and I will end on this thought, the advantage of Ben-Habib's discursive cosmopolitanism is that it gives us a concrete place to start. Whereas both Arendt and Habermas's proposals would require institutional change and far-reaching international reform, Ben-Habib's approach can work under current conditions and within existing institutions. In this way, Ben-Habib's discursive cosmopolitanism not only successfully mediates between the generalized and the concrete other, it also successfully mediates between the ideal and the real in a way that can lead to concrete political change in the present. For a scholar who started her intellectual journey with a dissertation on Hegel, I can think of no higher form of praise. So thank you very much for being here and for listening. Thank you, Shayla, for inspiring us all. And we look forward to many more years of inspiration in the future. Thank you. Unmute yourself, Tom.
Okay, can you hear me now? My button is not working. Okay, Christina, your turn.
Okay, thanks so much, Tom. I'm delighted, like everyone else, to be able to be in this wonderful event to honor Shayla's work. And I think we can honor it in the best way we can by engaging with it and see how far it can take us. And so in that spirit, I wrote a very long paper where I go in a lot of details, but of course, now we don't have the time. So trying to make an argument in 10 minutes is very hard, but I'm still going to try. So what I'm going to do is to present some slides. It's a way of cheating and trying to make it faster. Can you see the slides? Yeah. Okay, so what I do in the long paper is to try to articulate an account of legitimacy that fits, I think, very well with Taylor's way of thinking. Sorry?
Your paper is covering the slides.
Sorry. Okay. How do I do this? Is that now?
That's perfect. Thank you.
Okay. So what I do in the paper is try to engage with Saylor's thinking about democratic iterations, which I think is the core of his thinking about the concrete universal. And I draw this idea of legitimacy by contrasting it with what I call anti-democratic shortcuts. And then I use that as a way of judging the legitimacy of institutions. Let me see if I can move my slides, or what did I do wrong? Okay, let me see. Because now I can't move my slides. I'm sorry. Maybe it's not worth it doing this if it doesn't let me be faster as I thought I will be. Okay. Okay. Let's see what happens. I need to share this. Is that now showing? Yeah, okay. And can you still see it?
It seems to be the same page you had up before.
Okay.
Yeah.
Okay.
It says democracy without shortcuts, institutions.
Right. Okay. I hate technology. Okay. But can you now see the whole thing? Yeah, okay.
Cool.
Okay. So as I was saying, if one takes seriously the idea of democratic iterations, the core of what I will show, I think, is the idea, and use of the things of the opposite concept as democratic shortcuts, I think one can get a way of thinking about the democratic legitimacy of institutions that challenges the standard views according to which majoritarian institutions are per se or per default more democratically legitimate, whereas non-majoritarian and especially transnational non-majoritarian institutions like human rights institutions are kind of democratically suspect. I think that to oppose this way of thinking, one needs to, and that's why I got cut with this part of the argument in my long paper, and that's why I'm focusing on it. One has to see that the typical proceduralist account of legitimacy that deliberative Democrats defend, and that also Saylor endorses, actually goes against the idea of democratic iterations. You cannot have it both ways. I think there is a tension. So that's my claim. Well, I'm going to try to show you quickly, as I expected. And so, from the point of view of the institutional approach that I defend, the proceduralist view of legitimacy impedes democratic iterations, is a way that justifies the possibility for majorities to impose their substantive views on minorities. Okay, so here, let me show what I see as the main problem with proceduralism, as it has been defended by deliberative Democrats. Okay. So according to deliberative Democrats, political decisions can claim legitimacy only to the extent that they can meet with the assent of citizens. However, we all know that in light of ongoing disagreements, post-deliberative consensus is hardly to be expected. And that's why accounts of legitimacy have to focus on how to legitimize majority rule, the use of the capacity of majorities to impose their decisions on minorities. And so the idea is that if the legitimacy depends on citizens' assent, and the outvoted minority per hypothesis disagrees with respect to the substantive merits of the decisions, then the legitimizing effects of assent cannot flow from substantive consideration. It can only flow from procedural considerations. And that's why the key assumption of proceduralism is legitimacy cannot only be procedural. It has to be a feature of the procedures you are using and cannot be substantive. So Habermas, for example, defends this view with the help of Rawls's distinction between imperfect and pure proceduralism. And so he claims that post-derivative majority rule is imperfectly procedural because it cannot guarantee that its outcomes are substantively right. So we can never know just by virtue of being in discourse whether the outcomes of discourse will be just, will be good, will be efficient, or whatever the case may be. However, it is purely procedural because it can guarantee that the outcomes will be legitimate. So if the procedural conditions are met, the outcomes are legitimate, whatever they are. And there are no substantive criteria that are procedure independent. And so long as the procedural conditions are met, then you see why majority rule is legitimate. And in Between Facts and Norms, he gives a very brief account of this view. So this is a quote: because of its internal connection with a derivative practice, majority rule justifies the presumption that the fallible majority opinion may be considered a reasonable basis for a common practice until further notice, namely until the minority convinces the majority that their views, the minority views, are correct. And so we can express this view of the legitimacy of majority decision with the following principle. I call it pure majoritarianism. So the idea is then that we should let the majority prevail until the minority convinces the majority that their views are correct. Now, the problem with this principle is that most proceduralists recognize that there is a limit as to how unreasonable or unjust majoritarian decisions can be, and that legitimacy is undermined beyond that point. And different authors take different examples, etc. But the basic idea is that majoritarian decisions that threaten citizens' fundamental rights and freedoms are illegitimate, and therefore dissenting minorities have no duty to obey. Now, the problem is that if you want to recognize that principle, you need to modify the principle I have here according to something like this, which I call now modified majoritarianism. So that what we are saying is that we should let the majority prevail, except in cases where the majority decisions threaten fundamental rights. And now the problem is that I think this is a very reasonable principle, much more reasonable than the other one, but I think that endorsing it is incompatible with proceduralism. For two reasons. First, contrary to proceduralist assumptions, evaluating political decisions on their substantive merits is necessary in order to apply this principle. You have to look at the content, the substantive content of the decision to see whether or not majority rule is legitimate. And this is not necessary to see whether the decision is right or just or fair or whatever it may be substantively. It is to know whether its informant is legitimate. And so looking at the procedural pedigree alone is never enough to make such a determination. And then if that's correct, then we also need an alternative answer to the question of how political decisions can be legitimately enforced after the limits of procedural majoritarianism are reached. What do you do then? Because as we saw with the other principle, what we are supposed to do is to always let the majority prevail until the minority convince the majority, and that means forever. Here now we are saying, no, majority rule is not, then what do we do in those cases? So in my view, the institutional approach that I'm defending offers just such an answer to that question, and that's why I think it's better. So if we compare the two normative principles that I mentioned, pure and modified majoritarianism, the main difference between them is that for the first principle, procedures are necessary and sufficient for legitimacy. According to the second principle, however, majoritarian procedures are insufficient. That is all it tells us. The principle simply tells us that majoritarianism is never sufficient to guarantee legitimacy when fundamental rights are at stake. And so as a consequence, I think that this principle, modified majoritarianism, has to be interpreted as a recursive principle. And this is where Seila's notion of democratic iterations comes in. We need to have something like the ability to not to ban the use of majority rule, but to take away its finality. because that is what proceduralism is looking at. It's looking at some outcome that will be necessarily, irreversibly legitimate and therefore should stand, right? If we interpret what the principle does as a recursive principle, what it does is to take the finality precisely by justifying the legitimacy of contesting majoritarian decisions on substantive grounds, not on procedural grounds only, but because they, for example, as we claim, threatens our rights. And we can do so regardless of whether the majority is convinced. We should be able to do that, to contest that decision unilaterally, not dependent on whether we are able to convince the majority. And so decisions may be temporarily settled by majority rule, but only a settled view on the rights in question, on the contested rights, can bring the triggering of further scrutiny that the principle allows to a proper end. So following this principle, the institutional account of legitimacy, what it does is to add a necessary condition to the discourse conditions that proceduralists and deliberative democrats rightly identify as necessary. So it tells us that the legitimacy of majoritarian decisions also depends on the existence of an actual institutional opportunity to contest any laws and policies that citizens find unreasonable on substantive grounds by requesting that proper public reasons be offered in their support. And so the difference, the similarity is that according to this view, legitimacy is a property that accrues to outcomes indirectly by virtue of the existence of the right type of institutional arrangements, and not directly. It's not a function of that only of the correctness of the decision, like a correctness view of legitimacy will say. I think that is the gist of the proceduralist idea, but I think that is wrongly understood if you follow proceduralism. And so the difference is that the contestation of the legitimacy of a decision should be guided by substantive considerations and not by the number of supporters. But when you do that, then it's clear that legitimacy cannot be purely procedural. It cannot be warranted simply by having properly followed procedures, as in the case of majoritarian institutions. You really take away the finality, but making it dependent on substantive considerations.
Christina, could I ask you to come to an end? We're running out of time here.
Okay. So, well, basically that's the idea. And so you have to accept that procedural independent substantive criteria are relevant for legitimacy. But I argue that if you see the recursivity of the principle, you can let the decision of the substantive criteria that matters to be determined by the affected themselves. They are the ones changing, rethinking, reinterpreting the relevant substantive criteria. And proceduralism actually doesn't do that. It looks as if it leaves substantive considerations to the affected themselves, but it doesn't, because it's not sufficiently inclusive. It led the majority to actually have immunize their substantive views by virtue of having only majoritarian institutions. And the other point, of course, is that if you look at what these institutions are doing for us, how they are allowing the inclusive interpretation of discursive criteria, then we see why transnational institutions are actually in the service of localization and concretization, and not the other way around. And I think that's something we have learned from the work of Sheila, and I think that the institutional approach is so much more in the spirit than proceduralism. Okay, I'm going to leave it there. Thank you.
Thank you very much. And now we have finally Umur Bashtash as the last member of the panel.
Thank you very much. I'll try to be very quick. Just try to give you a sense of what I'm trying to do with Professor Ben-Habib's notion of concrete other and Kant aesthetics, try to make them speak to one another within the context of the broader question, whether our universalisms are necessarily exclusionary towards the non-human nature, and what we could do with this notion of the concrete other and with some aesthetic considerations in order to speak to this issue, essentially. That's the kind of broad question. What I'm doing is really a textual analysis, but I'm not going to get into that, just like try to show you where I'm coming from, where the question is originating, just to kind of give you a framework. So the question of nature, as you all know, is very prominent in the early Frankfurt School. Themes of reconciliation with nature, domination of nature, all of these topics very prominent for Horkheimer, Adorno, Marcuse, etc. Habermas's communicative turn is partly a response to the perceived impasses, deadlocks, that he associates with the preoccupation of the early Frankfurt School with the question of nature. But his turn to this kind of communicative intersubjective notion has an uneasy relationship with nature, let's say. The question about nature did not disappear from the agenda. Many critical theorists kept thinking about this, even working within the framework of communicative turn. And Habermas himself kind of kept returning back to this question. But there's an uneasy relationship, particularly because of the way in which we tend to think about what communication means. If we solely focus on human communication, human discursive ways of claim making, then it becomes difficult to conceptualize what it would mean for non-human beings to make recognition claims, to be participants in the moral community of morally significant beings that we value for their own sake. Therefore, the question of to what extent this is necessarily a kind of exclusionary universalism that we're expounding. So that's the kind of question there. Now, can we use this notion of the concrete other to somehow respond to this potential problem, to this difficulty? Originally, as you are probably familiar with, the term comes from the difficulties of focusing solely on the generalized other, meaning the other as abstracted from particularities, history, concrete history, simply a rational being as such. And the argument was that we both need to take into account the concrete other with its particular identity, concrete history, affective constitution, expressive claims, etc., and that this should not be excluded from the conversation and consideration. But of course, both terms are still meant to apply to human beings. Is it possible to think of non-human beings as concrete others? And here the issue is not just a matter of scope, so not just like adding a bunch of other beings into the basket of concrete others, but it's also an issue of competence, because we're concerned with what these, not just what these others are, but what they can do in terms of their claim-making actions, competencies in general. And most importantly, can we think of concrete others as making non-human yet normatively significant claims, truth claims? So that's really the key question here. And this is what motivates my turn to Kant's aesthetics, which is rather surprising for several reasons. It's not, if you have a project like this, of rethinking what the concrete other can do, turning to Kant here, Kantian aesthetics is an unlikely place for several reasons. Kantian morality is very anthropocentric, particularly because of the distinction between dignity and price. And dignity is ascribed by Kant only to rational beings capable of self-legislation, and price and all nature essentially just is potentially commodified sphere that has an exchange value, which is a kind of reflection of this capitalistic commodification of nature in general. So this is how he's operating with this dignity as the absolute value that we attribute to rational beings, and price to non-human nature. And that's a kind of clearly a difficulty, this anthropocentric element of Kantian morality. And Kantian aesthetics is also kind of an unlikely place to look here, because it is really sphered from morality and politics, particularly through the notion of the disinterested contemplation. So it's a technical term, what he means by this, but just to put it very simply, aesthetic experience is a disinterested contemplation in the sense that the faculty of desire is silent. So in the aesthetic contemplation of a beautiful object, What we're focused on is only the feeling of the harmony of understanding and imagination and the free play. And the faculty of desire is not supposed to be involved in this process. And because of that, we're not interested in the existence of the object that we're contemplating. So we don't care, say we're looking at an apple, when we're looking at it with the faculty of desire, we may be looking at it as satisfying our hunger, so as an actually existing object that we may consume or something like this. But in the aesthetic experience, that is not supposed to happen. We're just concerned with the representation of the apple, its color, its shape, etc. And we're unconcerned with its existence. Therefore, this disconnect from the faculty of desire disconnects the aesthetic experience both from morality and politics. So for both of these reasons, Kant seems like an unlikely place to look. So his morality is very anthropocentric because of the dignity and price distinction. His aesthetics is severed from morality and politics because of the notion of disinterested contemplation. Yet something very interesting is an argument I think is kind of underappreciated and that he's making. And this is when he's discussing the possibility of universal communicability of aesthetic judgments. So the aesthetic judgments are not something like mathematical claims where you can just like theoretical proofs that are supposed to be universally convincing. So it's not possible, according to Kant, to have a kind of theoretical universal communicability like this. So you need some other argument of why you can actually claim universal consent, even though it's an aesthetic judgment. And it's kind of long discussion about notion of sensus communis, etc. But what is of interest to me here is that his argument is that this universal communicability of aesthetic judgments presupposes that we actually take an intellectual interest in the beauty of nature. And what is the source of this intellectual interest in the beauty of nature? There's a kind of rift between the human and the non-human. Yet in the experience of this beauty of nature, we experience a kind of affinity between the two, and particularly in the existence of the object of beauty, and not just the form, but the existence. And it's a kind of very, very interesting thing. So when the very possibility of this amoral, apolitical aesthetics is grounded on the possibility of taking an interest in the existence of these natural beings as what I want to say, concrete others that we are encountering, and their existence valued for its own sake. And so this is the kind of connection that I find. As I said, I'm making a kind of detailed textual reading of this, but I'm not going to get into this. But you get our idea here. So somehow reconnecting this aesthetic experience of nature with the faculty of desire, therefore with action politics, in a way that is going to allow us to extend the notion of dignity and therefore the concrete other as somehow be capable of claiming recognition to be valued for its own sake, allowing us to rethink our universalisms, essentially. So that's.
Thank you very much. Can you hear me now? Is my mute? Yeah, it's working. Okay, according to the schedule, we only have 5 minutes left to our session. So to leave at least room for one or two questions, I'm going to boil down my remarks to 1 to 2 minutes. Basically, I'm an unreformed philosopher, and so I'm going to look at the philosophical side of this, go back to the writings of the 1980s, the 2 books in which she laid out the program for communicative ethics, which I think is an enormous accomplishment, using Hegel's critiques and then later Hannah Arendt and feminist critiques and so on to mediate the universal, in particular the universal and the concrete, in a way that hadn't been done in that tradition. And she's gone on and on from that. My question is going to be the question I'm going to focus on, and I'll talk about that sort of Hegelian way of sublating the objection and incorporating it into a new movement of the concept, that is, of her conception. But what I want to focus on is what I think is a danger on the universalist side. Most people are worried about is it supple enough to accommodate all of the different particularities. I think by naturalizing, in effect, the universal, by not regarding it in transcendental terms or even in terms of cultural evolution or in terms of Habermas's universal pragmatics, although she uses that term sometimes. The problem is if it's something that arose socio-historically under contingent conditions, then the form it's going to take at any particular time and place is going to depend a lot on contingent conditions. As we see now all over the world, including in the United States, you can have universal formulae, but once they're faced with but once they're understood in a contextual way, everything comes up for grabs. That is, the particular, so to speak, comes to dominate over the universal. I'm not sure there are theoretical ways in what Sheila's done with the idea of pragmatic presuppositions that allow her to resist this. Okay, I'll stop right there. If the people who are running question and answer want to throw out a question, maybe we can at least deal with one of them. Is there someone who is?
Yes, thank you so much, Professor McCarthy. So we have several questions from the audience. We'll start with the first one from Professor Nadia Urbanati, and this is a question for Professor Lafont. So I'll just read out the question here. It seems to me that in your presentation, you ground your reasoning of an assumed dualism of form matter or form substance. Yet a procedure is hardly a static cast that imbricates public doing. A procedure is embedded more than abstractly imposed a procedure is embedded more than abstractly imposed on as an extra procedural thing or matter. The issue of legitimacy emerges, however, because of the radical immanence that democratic process entails. Hence, even the reference to substance or issues concrete becomes an object of contestation or disagreement. And again, you need a procedure to deal with this. There's no question there, but it's an invitation to comment.
Sure. No, I think, Nadia is just putting the finger exactly on what I think it matters here. I think that the idea of proceduralism as a way of understanding legitimacy is really missing the point, because I think it probably meant institutional approach all along. Institutions can handle changing their own procedures, reinterpreting them, changing their substantive criteria. You can do that within a institutional arrangement. But you cannot do that if, say, the procedure that you're singling out is majority rule. Majority rule is not, especially with secret ballot, and if it's inclusive, right, does not allow you for that type of contestation. We see that now, for example, with election. If a question is purely procedural, we are not accepting arguments that are not about whether the procedure was correct, about whether who won the election, right? So there is not, we are rejecting the idea that because the wrong candidate, according to someone, won, right, for probably program or substantive reasons, right, we should not accept the legitimacy of the election. We don't accept that. Majority rule has this feature, namely that it depends on whether the procedure was properly run. And if it was, then that's all there is about legitimacy, that the legitimate president is the one that won the majority, right? I'm saying that when questions arise, we cannot accept that, because then there is no space for minorities to question the legitimacy on substantive grounds. And so I think that to claim that actually there is a change in a possibility of reinterpretation of democratic iteration requires to think like one step higher, namely institutional arrangements that allow for that they themselves can change their own criteria and their own procedures. But procedures such as majority rule do not have that flexibility. And I think that kind of putting all the legitimacy on majority rule is exclusionary. That's the claim.
Excellent, thank you. We have a question from Professor Benhabib, so I'll just invite her to unmute herself.
This may be a little too early to get into the discussion, but let me just say, I do not consider my position to be a pure proceduralist position. It has always been, my position has always been a much more hermeneutic one. And I've always criticized, Habermas from the beginning in Critique, Norm and Utopia for not leaving enough room for this moment of interpretive indeterminacy in the procedure itself. Every procedure needs interpretation, and you cannot step outside that. So you are always in the interpretive circle. And I agree with Christina that the way I've always thought of discursivity, even within the context of democratic iterations, involves minimum right guarantees, and rights themselves need to be iterated within the process, right? I mean, if we interpret equality as equality of conversation rights, but as in any department meeting, there's someone who is setting the agenda, then we have to push the equality of conversation rights, maybe also to the equality of being able to set the agenda, right? So this hermeneutic problem has always been present to me. And I mean, we're having an interesting discussion with, Christina's wonderful book, that in philosophy and social criticism, the full discussion has appeared. But whatever the critique of, this majoritarianism, this is not, I don't see myself as properly characterized in that kind of disputation. I shall have something to say about all the wonderful comments, including this issue that Tom and I are going back and forth on in the late part of the afternoon. So let me just stop here right now.
Thank you so much. The next question is from Devin Gore, and it's a question for Professor Bajdat. And I'll just read it out here. I wanted to push you a bit further on your comments about the uneasy fit between Habermas's communicative framework and moral respect for nature and or non-human animals. More specifically, you turn to Kant's idea of our direct interest in nature in the Critique of Judgment. But it's worth recalling that Kant's turn to nature here is in direct contrast with the previous few sections, in which he argues that an interest in sociability, i.e. communication, is, unlike our interest in nature, merely empirical. Indeed, he argues that an interest in sociability may even distract from the disinterestedness and independence required for aesthetic judgment. I wanted to see if you could speak more about whether the same tension you see in Habermas also arises in Kant's third critique. Thank you for the presentations.
Yes, definitely. So, I mean, this is exactly the part that I'm talking about. Very, very good question. So I think that distinction is how Kant manages to avoid what would actually be a contradiction or inconsistency in his argument. And it happens as follows. So he makes a distinction between our empirical interest, which we have as a kind of social being, but as a kind of with Rousseauian undertones, with lover of art and luxuries, etc. So the beautiful things that we do to be seen with the eyes of others, by the eyes of others, and then the intellectual interest in the existence of natural beings for their own sake. He presents this as a solitary experience. So we actually do not seek to share or communicate this experience that we have in the existence of these natural beings for their own sake. And thanks to this, Kant can just leave this argument that interests me devoid of its potentially problematic implications for his overall argument, because after evaluating these natural beings, having that intellectual interest in them, we don't actually have to go back to society and share it and make an argument in their name or something like this. So all of the implications that I would actually want emerge from Kant do not emerge precisely because of that strict distinction that he makes between the empirical and the intellectual one. But I would personally, I mean, the way I would actually approach this is to question that very distinction and to argue that Kant actually cannot avoid the potentially problematic implications. So just like rethink that empirical intellectual interest distinction and repoliticize his argument about the intellectual interest in the existence of natural beauties. That's. But yeah, I mean, it's a long debate. I'm not going to get into this, but yeah, very, very good question. Exactly my concern.
Thank you. We have time for maybe one or two more questions. We have a question from Maeve Cook, Professor Maeve Cook, for Professor Lafont. I'd like to invite her to ask the question in her own voice. So I will now invite you to unmute.
Thank you. I wasn't prepared for that, but it doesn't matter. To be quick, I agree with Christina that majority, for example, majority rule cannot be challenged purely on procedural grounds, that we need some substantive grounds with some degree of independence. How should we evaluate the quality of these substantive grounds? And second part of the question, how can Sheila's idea of democratic iterations help us here?
Thanks so much, Maeve, because that is exactly the part I could not present because of lack of time. That is where I think, like, if people is willing, and it seems to me that Sheila should be, and I'm sure you are, Maeve, too, are willing to understand that we do actually bring substantive considerations, even to legitimacy, and not only when we judge whether the decision is correct, then is when you see why you have to go one step higher than proceduralism. You need to go institutionalism, so to say, because once you have an institution, imagine even like judicial review as an institution, you can see how over time, those who bring cases to the court are the ones actually concretizing, changing the criteria, making the principles as good as they can be for their own case. They are the ones doing the democratic iteration, because they bring the cases in the best light they can. And in so doing, they may change the principles that we all were assuming were the right ones to judge the case. Even in transnational contexts, like Angelica's case, right? You can change the view of rights and think that there can be such a thing as rights to nature if you have the voice in the institution to actually make your claim and reinterpret the principles. So to me, that is completely in the spirit of Sheila's idea of democratic iterations. But you can do that if you think of really institutions that do not have a built-in substantive understanding that cannot be changed of what those are. Like, we may think even that a constitution has a completely saturated list of rights. It doesn't. Those are unsaturated placeholders. Who saturates them? Whoever has access to those institutions. So what matters is to have inclusive institutions that allows the affected themselves to give their own substantive interpretation, and that can change. And if we put all the bets, so to say, on the procedures themselves, then we lose that ability that we are all claiming is important. So that's how I see that. And that's why I think democratic iterations versus shortcuts is the right kind of contrast concept to see how to judge whether an institution is properly democratic. If it allows this iteration process and is inclusive, then that is a democratic, legitimately institution. And so human rights transnational institutions can be seen in that light, rather than seeing them as a kind of top-down way of imposing a homogeneous interpretation of rights. Well, that may be what they do, especially if they are not inclusionary, but if they are properly inclusive, then that's not what they do, because those bringing the cases will try to make the best substantive interpretation they can for their case. And in so doing, over time, they will change people's hearts and minds. That's the hope.
Thank you. So we're running a little bit over time, but we'd like to give the last question to Svenja Alhaus. I'll invite you to just ask it in your own voice by unmuting yourself here.
Okay, can you hear me?
Yes, we can hear you.
Okay, great. So my question is for the first three panelists who discussed the question of democratic iterations and jurisgenerative politics. And you all emphasized the positive dimension of crucial legal and political developments concerning rights of nature, decolonial or refugee and non-citizen movements. And I was wondering which role you see for the concept of democratic iterations in times of political regression. So in dark times, my question would be, what about Ben Habib's idea of jurispacific politics and the risk of undemocratic iterations? So is there any way to determine whether the developments that we see actually go in the right direction, and how we can evaluate that? Thank you.
Professor McCarthy, I can leave it to you to assign that question. It was potentially for Professor Bernal, but any of the first three panelists.
I must say I had a hard time understand. I couldn't hear. I wasn't hearing well. And so I didn't get the drift of the whole question.
Perhaps we could have Professor Bernal start with the
Yes.
response.
Yes, I'm happy to start. Thank you for that question. I think that one of the things that, at least in the case I'm looking at, is that it's not that you have first sort of democratic progressive moments and then regressive moments. The temporality of it is that it's happening very mixed. And in fact, in the cases that I've seen with rights of nature, the democratic iteration and the power of it is that then these norms that are now reinterpreted and reappropriated then become bulwark for those regressive moments. So you have this competition in the case that I looked at between the state and its interpretation of the rights of nature as somehow coinciding with extractivism, and then popular movements and popular constitutionalism, and then the courts as well. And it's just a multiplicity of this struggle going on, and that in fact this is a really fruitful process that I think with these cases, it's kind of, if without these measures and without these iterations, the regressions would have been deeper in terms of the elements of violence against these populations. And it has afforded them a language that they wouldn't have had before, and legal tools and legal possibilities of defense that they wouldn't have had before. But it's important to not limit the temporality of it.
Thank you. And perhaps we could have Professor Lyndon Redick end with this session with a response to that same question.
Thank you, Nishan, and thank you, Svenja, for the question. It's great to hear your voice. I just would underline what Professor Bernal said. I would just say that one thing that might be interesting to think about is the degree to which kind of regressive political developments are in fact not iterations at all, insofar as they seek, I think, in the same way to kind of undermine the temporal quality of their decision making. So the idea of kind of regressive, xenophobic right-wing populism precisely seeks to kind of erase the temporality and the fallibility and the kind of embeddedness of the decision, insofar as it presumes to be made on the basis of a revival of a nostalgic past that sutures and kind of fixes in place certain kinds of identities. And so in some sense, I can imagine that there are undemocratic interpretations of norms, but we can use democratic iterations to even criticize those undemocratic interpretations, insofar as those regressive moves seek to pull out the rug from other actors to then in the future reinterpret those norms again. And so there's kind of an analytics based into that. And just in the same way for the jurispathtic nature of kind of certain court-based decision-making, Robert Cover, was very attuned to the ways that the jurispathtic and the jurisgenerative are often very much working in tandem, and that because of the jurispotency of norms, courts and actors have to decide. There is a moment of decision where that jurispathtic move closes off the recurring iteration of norms into the future. And yet, there's a sense that the Cover held out hope that any jurispathtic move could actually entertain in the future a jurisgenerative redemptive movement by others. And there's something to be said for the idea of a judicial opinion or an articulation of a particular rights claim that makes it possible in some meaningful way for others to take that up again, and it kind of foregrounds its own particular limited reach of the claim that's being made. I think that's important kind of analytically to kind of think about criticizing when behind the veneer of democratic agency, various social forces presume to exclude and to undermine that recursive process of legitimation. So I think it's a brilliant question. I think that we can kind of parse it a little bit to revive some kind of sense of judgment about what is an undemocratic articulation of a norm and what is a democratic iteration. Thanks again, Svenja.
Thank you. And I'll just pass it back now to Professor McCarthy to conclude the session.
Okay, thank you all for an excellent session.